Did you know that your website could be at risk of a lawsuit right now? And the fines are unbelievable. Stay tuned. I'm going to show you all about it. Hey there, Dan Brown here, Senior Service Consultant of MGE and partner at Bloomberg Digital, the digital marketing company that's servicing numerous MGE clients across the country with their digital marketing goals and needs. I know you just heard from me with news and updates from the marketing world, but another extremely important news flash just came to my attention this past week, and I'd be remiss in not going another day without sharing this with you. In fact, not knowing what I'm about to reveal could put you at risk for losing thousands of dollars and being subject to a lawsuit. Yes, a lawsuit. So what am I fussing about? It's called the American Disabilities Act, ADA for short. And dentists in California and abroad are actively getting sued because their websites aren't in compliance with its regulations. Now, one of our clients let me know about this and that it was going out amongst their friends. And this is real. This isn't just news hype. So thank you for the client who alerted us. We have done extreme homework on this, and we're going to tell you all about what we found. Now, why is this happening? Well, your website should be, quote, reasonably accessible to people with handicaps, particularly those who are deaf, blind, and have learning impairments. And if it's not, it's grounds for a trial. We'll get to exactly what, quote, reasonably accessible means shortly. But first, if you haven't heard of the ADA, here's a bit of background information that you should know. The American Disabilities Act, it was signed into law in 1990 with the purpose of eliminating physical barriers for people with disabilities. And in time, its scope expanded. And some 20 years later, in 2010, the U.S. Department of Justice, the DOJ, announced that the rules would apply to accessibility standards to all websites. Now, Dental Economics reports that the DOJ was slow in executing this, and they never actually got around to writing any rules. Then, in December 2017, the DOJ announced that they actually weren't going to issue any rules. As a result, this absence of specific ADA guidelines has created a very fuzzy regulatory environment with varying interpretations of the law, which is highly dependent on the judge involved. In reality, it's an open invitation for lawyers to file lawsuits to test the court's limits, which is exactly what has occurred over the last several years. Since the Department of Justice first suggested that they weren't going to make any rules, there has been an explosion of lawsuits. I've been reading reports stating that even celebrities and big retailers have been hit with lawsuits over recent years, such as the wildly famous American singer-songwriter Beyonce Knowles Carter, Winn-Dixie, Target, and as just a couple of weeks ago, Domino's Pizza. Most of these entities have had to spend hundreds of thousands of dollars to fix their website after being sued. And that's not including the cost of payouts, legal representation, and loss of revenue from upset members of the public. Ignoring or being lazy about compliance just aren't worth the cost, not to mention the bad press. In fact, fully 1/3 of all ADA lawsuits today concern website and app accessibility. Let's take a deeper look at how these cases have surged over the past years. In 2015, when the DOJ was still talking about creating website rules, only 60 accessibility lawsuits were filed in federal court. In 2017, this increased to 814 lawsuits. In 2018, the number rose to 2,258, which is a whopping 177% climb. The curve then flattened, and after a very slight dip in 2019, numbers rose 12% in 2020, even during the pandemic. In this graphic, you can see how website accessibility lawsuits have skyrocketed from June to July of 2020 and averaged about 279 per month for the rest of the year. And here's the breakdown of website accessibility lawsuits per state of 2020. New York, with 1,694 lawsuits in 2020, experienced nearly 6 times the amount of website accessibility lawsuits than any other state. 6 times. That's huge. Florida was second with 302, and California took third place with 223. Now, in 2021, lawsuits are increasing again to new record levels. And it's not just the US who is enforcing website accessibility standards. The EU, South America, Australia, New Zealand, and Canada have all had various levels of website accessibility requirements that demand being in alignment with the Web Content Accessibility Guidelines, commonly known as the WCAG. And these were developed by the World Wide Web Consortium, also known as W3C. W3C is a group that was founded in 1994 and is the main international standards organization for the World Wide Web. Now, the WCAG, these are not laws. True to their name, they are just guidelines. The W3C won't legally penalize you for not following their specific guidelines to the letter. That said, there are web accessibility laws that vary by country. If you break these laws, you could face sizable legal or financial penalties. And it's crucial to understand and follow these laws to ensure that websites are compliant with the accessibility standards relevant to their specific countries and others. Let's talk about Canada quickly, because a major deadline just passed last week for website accessibility requirements. According to the American Marketing Association, Canada's web accessibility situation is very similar to that of the United States in that web accessibility laws exist for government sites, but not for public sector sites. Canada's standard on web accessibility went into effect in 2011 and requires government sites to meet WCAG 2.0 standards. The standard ensures the uniform application of high-level web accessibility across Government of Canada websites and web applications, and is still a helpful document for public sites. However, it only extends to government websites. But there are public sector accessibility laws in some parts of Canada. Ontario, Manitoba, and Nova Scotia all require public sites to be compliant with WCAG standards, and more provinces have proposed similar laws. Along with the EU, Canada is becoming increasingly concerned with accessibility, so it's only a matter of time before such laws are put into action across the country. And Canada is taking web accessibility extremely seriously. The Accessibility for Ontarians with Disabilities Act, AODA, which is similar to the US's Americans with Disability Act, imposes hefty financial penalties on any site that isn't compliant. A corporation or organization that's found guilty could be fined up to $100,000 per day. Directors and officers may additionally be fined for up to $50,000 per day. Did you hear what I just said? $150,000 in fines could be charged per day. Wow, that's brutal. The AODA states that any entity that provides goods, services, or facilities to the public and has one or more employees in Ontario must comply with the WCAG's web accessibility standards, in addition to the Government of Ontario, Legislative Assembly, and all designated public sector organizations. And bigger businesses have even stricter requirements. According to Medium.com, larger entities must also establish and maintain an accessibility policy and plan and make it publicly available on their website. In addition, accessibility training must be provided to employees, volunteers, and those who make goods and services on behalf of the organization. For Ontarians, a June 30th deadline for submitting WCAG compliance reports just passed, which was required by business owners with a certain number of employees. This deadline was extended by 6 months from January 1st due to the COVID-19 pandemic. Let's jump back to the good old United States of America and take a look at the ADA's penalties for noncompliance to the WCAG in America. If you receive a website accessibility demand letter under the Americans with Disabilities Act, $25,000 is a conservative final tab after you're done at the buffet of the plaintiff's law firm. From Medium.com, here's the itemized bill for smallish businesses. $5,000 to $15,000 plaintiff's law firm fees, $5,000 for your defense attorney, $5,000 to $20,000 for your website app, audit, and remediation. And this is no exaggeration whatsoever. Compared to Canada, these fees seem almost tolerable, but they're certainly a monstrous bite in the wallet. As you can see, compliance is definitely not something to take lightly and is going to be an increasingly hot topic of conversation from here on out. Now, you may be asking, but why are dental practices specifically being targeted for lawsuits in America? Well, the California Dental Association says there are a few reasons. Those looking to file suits for profit can browse through hundreds of dental websites from the comfort of their computers. Dentists aren't expected to be web experts, nor have web content that's updated as often as e-commerce businesses, so their sites are less likely to be accessible. No pre-filing notice is required. This means dentists don't have the opportunity to make the changes needed to comply, and plaintiffs and their legal firms are often simply just seeking payment, not fixes. Did you get that? They're seeking payment, not fixes. Simply put, finding non-compliant websites and filing litigation is too easy due to several factors, which I'll go over momentarily. The CDA states that even the most skilled and seasoned dentists face professional liability claims. But how would you feel if a lawsuit was filed by someone who wasn't a patient or who hadn't even driven past your office doors? Most dentists and other small business owners earnestly want to comply with well-intentioned ADA legislation, and costs to do so are also not easy on the wallet, to say the least. Some are hiring compliance consultants at a rate of $10,000 plus $500 per month to continually oversee that all regulatory requirements are met. Okay, by now you're probably thinking, Dan, we get it. Websites, dentists being sued. I'm a dentist. I don't want to be sued. So what do I do? Okay, well, I'm glad you asked. There are several things you need to make sure are in place on your site, which you can discuss with your website developer and hosting companies. Here they are. What makes a website compliant? Well, the courts generally refer to a set of industry standards laid out in Web Content Accessibility Guidelines, the WCAG, which we already went over and can be quite stringent. These criteria include, but are not limited to, 1 point, alternative text for images and non-text content, which is written copy that appears in place of an image on a web page if the image fails to load on a user's screen. This text helps screen reading tools describe images to visually impaired readers and allows search engines to better crawl and rank your website. Another point, video closed captioning or subtitling for the hearing impaired so they can read what's being said. Proper structure to work with screen reader technology, which is software programs that allows blind or visually impaired users to read the text that is displayed on a computer screen with a speech synthesizer or braille display. Let's talk colors, contrast, and text sizing to facilitate readability. This falls under design, and we won't get much into that here as I cover this extensively in the MGE New Patient Workshop. But have a look at this graphic. You'll see high contrast and lower contrast. The lower contrast actually being hard to read, but in fact, it's actually irritating and can cause problems with those visually challenged. Another point, predictable page order and understandable navigation. To expand on this point, the World Wide Web Consortium explains that people who use screen magnifiers only see part of the screen at any point in time. A consistent layout makes it easier for them to find navigation bars and other components. And the last criteria is having the ability for users to avoid or correct input mistakes. For example, providing safeguards to avoid serious consequences resulting from errors such as booking airline tickets for incorrect dates or purchasing more stock than intended, resulting in major financial loss. This helps users with all disabilities who may be more likely to make mistakes because of their disabilities. But think about it. This applies to all of us. We all want to, if we make a mistake, and for you, while you're not talking about stocks or purchasing airline tickets, if you do online scheduling, you want that person to be able to unmake that mistake if they make a mistake. Now you get these points. How do you know if these criteria are in place or not on your practice's website? Do you need to spend a ton of money to hire a consultant to keep up with the ADA's regulations? Well, not necessarily. you can actually conduct an accessibility audit yourself. Now I'm going to go through some options of what you can do if you want to do this yourself. If you don't want to do this yourself, reach out to somebody at Bloomberg Digital and they will help you get help with this, okay? But I'm going to go through some of the things you can do yourself. So Google Chrome's Lighthouse extension allows you to enter your website into an address bar and determine if it's compliant. All you need to do is download the Lighthouse Chrome extension by typing Lighthouse Chrome extension into Google's search bar and clicking on the first link that pops up. If your website is built on a WordPress platform, you can also have your developer install a tool called UserWay. This widget brings your website into compliance with governmental regulations as required by the ADA by instantly remediating accessibility violations. In addition, you can hire a third-party company to monitor your site's accessibility on a regular basis for a nominal fee through AudioEye. AudioEye will even act on your behalf if any legal issues arise, and they have an outstanding track record for eliminating claims from predatory plaintiffs. AudioEye also offers a free website accessibility checker that can determine your site's current level of compliance. Visit www.audioeye.com/website-accessibility-checker to check it out. If any of this is too difficult, contact the team at Bloomberg Digital and they can help you arrange to have some of these things done. Reach out to Alexandra Hamilton, who can be reached at alex@bloombergdigital.com. Okay, so now that you have some understanding on how to be proactive regarding website accessibility and any amount of courthouse catastrophe, why else is all this effort worth the trouble? Well, I'm going to go over something that has to do with something you will need to know or could use right now. You will reach a broader audience. According to the Center for Disease Control, about 61 million adults in the United States live with a disability. That's 26% of the population. 1 in 4 Americans. That's a huge sector of our country. And according to the American Foundation, about 32.2 million classify themselves as having a visual impairment. The U.S. Department of Health and Human Services reports that 1 in 8 people in the United States, that's 13% of the population, or 30 million people, aged 12 years or older, has hearing loss in both ears, based on standard hearing examinations. If your website caters to these individuals, that's a pretty enormous public you're reaching. Having a website that is accessible and can be utilized by all increases your potential target audience. So, from a business standpoint, accessibility means a larger target public, a larger audience, a larger happy audience, more business for you, and of course that means more potential profit. That, for me, makes this a no-brainer. Next, being ADA compliant helps build your practice's brand name. Brands that put forth the extra effort to implement accessibility, even when they aren't necessarily required to, depending on the country they're in, show their audience they care about people, not just profits. Catering to and accommodating your audience says a lot about your brand and the values you hold as a company, which can help strengthen customer relationships and loyalty. Next, an ADA compliant website helps with search engine optimization, which, if you've been following my channel, you know I've talked about a lot in past videos. This helps SEO because compliance supports SEO-friendly components like alt text for all images, transcripts for videos and audio, proper headings, and consistent and predictable structures, which we already discussed. The more accurate and more descriptive your alternative text is, the better it will work for screen readers and search engines. Transcripts give search engines information to scroll, meaning they have more keywords to work with. So the more that these things are in place, the better it is for search engines and for your public. Well, that's my news update for you. Please email me if you have any questions on anything I've laid out for you. I know I've just given you a lot of information, and if you've had any colleagues or friends who suffered any legal issues regarding this topic, let me know. I'm curious. I want to know, and I want to see if I can help these people. And as always, if you need any help on any and all of these issues, marketing or practice related, let me know. My job is to make sure you and your practice are continually winning and thriving. And if that's not happening, I want to know all about it. My email address is danb@mgeonline.com. I'm standing by for you, and we will see you on the next one.